shorthand, forgive me.
Okay.
And now, there was something that was very interesting about a juror that was not sequestered and was able to basically roam the hallways and had overheard testimony and other parts about this case, and it felt that they had become tainted, and actually had stated twice that they felt they couldn't put a fair effort into the hearing after what they had heard, and was still forced yet to stay on the panel. Now, at that point, did you, I should say first, was there any discussions between that juror and the rest of the jurors as to what they had overheard?
I don't remember specifically, but and I'm not sure if it's the same juror, but like as I stated earlier, that somebody either heard something or one of either Ben's or George's family said something to a juror outside. That was talked about at the time. I can't remember exactly what was said, but that juror did not leave.
Okay, but what was stated, what the juror did overhear, to some extent, was spoken about between the rest of the jurors.
Yes.
Okay. Someone overheard what and was not excused. Well, my next question would be, at that point, do you feel, then, you did say that you felt that that person should have been replaced, but do you feel that it would have been appropriate then for them to have either brought you in? And if so, do you feel that there was any, maybe, I don't know, bias or prejudice either against you or anything of that nature?
Well, first of all, at that point, I didn't know. I was still, like, in the proceedings. I didn't know that I was the alternate juror at that point, so we did expect, I think we thought, oh, then this person will be gone, and someone else will come in. And I don't know that we all looked at it like, well, we're all tainted now. Mm-hmm. You know, I mean, I think it was more like kind of tunnel vision. Oh, they spoke to that person, or that person heard it.
Okay, I got you. Now, as for the investigator, his name was Laverne Doctor. Laverne Doctor happens to be a member of the Wolf clan. It's from the same nation and tribe, the Onondaga Nation, as the Printup family. Now, the question there would be that this man was responsible for holding, the evidence for and handling the evidence for the DA. Do you feel that was appropriate?
I didn't know that at the time, and no, I guess that would. I guess if someone in my family was sitting where Benedict was, that would be an issue for me.
Okay. And now, my understanding was also that Mr. Doctor had gone in and out of the juror's room on several occasions. Did he, for any chance or reason, interact with the jurors at all?
Not that I recall. Mm-mm.
Also, do you feel, as it seems that you have, and I'll obviously will ask you to do this, so I will write this down and, shall we say, really focus in on it. You did say that you felt there was something wrong with the trial. Overall, if there were things wrong with this trial that you believe should have led to a mistrial, what would those have been?
Let me see. Like, I don't know. Maybe it's. I felt like the district attorney was like, or the prosecutor was like. It was like it seemed, and it again could just be my perception. It seemed like it was like a personal attack, like the way he spoke to and about the witnesses that were for the D'Agostinis were it seemed very like personal, like I can't even put my finger on it, just like some of the questions, obviously, and I know that happens in trials and stuff were like irrelevant and just like hurting their character. Mm-hmm. But it just seemed like very intense, like zealous, almost like personal. That
personal issues, or
yeah.
let's say a malice or a hatred.
Yeah.
almost for the defendant
Right.
at that point. And of course, if you're saying this is from the DA, and of course the DA started off his statement saying that he's representing the Print-Up family.
Right.
So it did seem at that point, I guess, from what I'm hearing, that they were almost stacking up the deck against him on that level,
Right.
because the general feeling was it was an unfair trial from your point of view, basically from start to finish, because this is what I'm gathering from what you've said. Okay, fair enough.
Okay.
Fair enough. Did you feel then, seeing that there was, because you had stated there was a lot of hard tensions between the families, between the prosecutors, the way things were going, did you feel that a change of venue would have been appropriate?
A change of venue may have helped him.
But shall we say, but not so much to help him. I'm more interested in keeping it fair and for the trial itself to be fair. I mean, is that safe to say?
I think that might have changed the atmosphere. I guess let's put it that way.
And now, the judge himself. The judge had stated, after the jury had been in deadlock for 2 days, that he was looking for there to be an answer on this case. He did not want there to go past 11 o'clock. He wanted the answer by 11. Do you feel that, shall we say, lended undue pressure towards the case, towards the jury itself, to make a decision?
I'm sure it did, and I know that. I mean, I wasn't there. I'm sure that put pressure on them. And I know when I was there, several of them were very itching to get back to their normal everyday life, to be done.
I understand.
Which, I mean, I don't know that I'm not saying that they're wrong for feeling that way, but I know that was a feeling too amongst the jurors, like, let's go.
Oh, absolutely. And remember, there is no judging here. Again, like I said, I'm trying to be as impartial, even though I myself, as anyone else, would have their own views. I really am trying to be as impartial in gathering this information from, again, so to speak, the persons that were actually there and this, had undergone this. But again, you were saying that there was a certain amount of pressure, but, they're being gridlocked for 2 days. Was there at that point a pressure because of what the judge had said, or that feeling overall to, if there was a problem of, let's say, it was acquitting the defendant, instead they would sway towards being guilty at that point so they could just get the thing over with and say, okay, it's done, all right, enough, he's guilty?
I mean, again, I wasn't there, I can't say, but that may have been a factor in it. I mean, at that point when they were deadlocked and deliberating, I was not there.
I understand. Well, if you had been, instead of a, alternate, the regular juror on the case, what would have been, from hearing all of the testimony, your overall feeling, what would have been your decision? Would you have acquitted or found guilty?
I think I would have, I don't think he, let me say this, I don't think he was completely innocent. Obviously he did do it. If the charge was different, I would have been more towards guilty. With this charge, I mean, when I left there still, I was just like, I don't know. I was just like, I wasn't swayed 100% when it was over that he was completely guilty of.
But yet and if this was a feeling of one, it stands to reason that this would have been a more overall feeling for everybody. And again, at that point, you were excused before they sent in for their final deliberations, but you were there for the duration of the trial. Yes. And again, this was something that was, an overall feeling that you can speak to. And it seems that, from what my understanding is that, there was shadow of a doubt as to, the goings on, and yet at that point they did find him guilty, and it seems that would have been, it would have been inappropriate, because there is, of course, a due process of law, and you have to give everyone their fair shake, and of course, being said, to be found beyond the reasonable doubt. There was no question, like you said, that this incident had happened.
Right.
That there was an altercation between everyone who started it, whatever. But at the end of the day, he did the stabbing. Okay, he defended himself and his wife against several men. This is an unfortunate situation that can happen to anybody.
Right.
But your overall feelings is that this trial was not handled appropriately. There was a lot of pressure, and either a mistrial or a change of venue would have been appropriate to give it a more fair, balanced looking at. So this way there wouldn't have been a railroad job. Even as far as the sentence being 18 years is kind of kind of strenuous for a defensive manslaughter. That's a heavy sentence. Mm-hmm. And my understanding after reading the notes is that the judge was saying during that time that he was going to make an example, of Ben, and I'm going to give you the full on harshest punishment. So that does lend towards everything that you have told me.
Right.
So, okay, excellent. So I'm going to sign this one off. I wanted to thank you so much again for your time. Let me just sign off.